4 things you should never put inside of your will and what to do with those instead. The first one's going to be assets inside of a trust. The trust owns those assets. You do not own those assets. Any assets listed on your will are only talking about the assets you hold in your personal name and how to distribute those assets during the probate process. Because the trust owns those assets, even though you have listed them inside of your will, they hold no weight because you don't own those assets. The trust owns them. The next one's going to be retirement accounts. You should not be listing your retirement accounts on your will. You should be listing designated beneficiaries on those retirement accounts. The reason being is that if you do not name a designated beneficiary and all you do is list them in your will, that money will have to go through the probate process before it gets distributed out to your family. If you list a designated beneficiary, that money gets automatically distributed out to your family when you pass away and avoids the probate process. The next one's going to be life insurance and annuities. Again, list designated beneficiaries and make sure that you are updating these designated beneficiaries. As an example, if you get divorced and your ex is still listed as your designated beneficiary on these accounts, then they will get that money when you pass away, even if you don't want them to, or even if your family deserves to have that money. And then medical or life support decisions. So this should not be listed in your will. It should be listed in a living will, a healthcare directive, or a medical power of attorney. The reason being is that a will is used to outline the distribution of your assets and goes into effect when you pass away. A living will or a healthcare directive is going to outline the types of medical treatments that you want to have for when you become incapacitated or when you go through end of life care. And then a medical power of attorney will allow someone to come in and make those decisions on your behalf and follow those documents. And so this will be things like do not resuscitate orders, feeding tubes, what types of medical treatments, prescriptions, or surgeries you would go through, or the religious beliefs that you need to follow. And then property owned by an LLC. So you do not own that property. You typically own the LLC membership interest. And so if you list the property in your will, it will not hold any weight on how that property should get distributed because you don't own that property. You own the LLC membership interest. So what you need to do instead is list the LLC membership interest in your will and how that needs to get distributed out to your family. So let's recap on how we should be structuring this estate plan for these things. Assets listed in your trust need to only be talked about in your trust document. And then if you are buying and selling properties and you think you might forget to or not have time to put assets inside of your trust and you need to have a will to capture those assets and talk about how to distribute them out to your family, you can create a pour over will. It will capture any assets still in your personal name when you pass away, send them through the probate process, and then dump them back into the revocable trust at the end of probate. The benefit of this is that if you forget or don't have time to put the assets inside the revocable trust, we'll dump them into the revocable trust so that they can be managed and distributed per the rules inside of that revocable trust document. You would just list designated beneficiaries on those accounts. It's typically going to be a spouse, your children, or a revocable trust. The revocable trust typically has the worst tax benefits, with your spouse having the best and your kids having the second best. If you don't list a designated beneficiary on those, they will have to go through the probate process before they can get distributed out to your family, and they will be accessible to creditors coming after that money to pay off debts that you owe them. And then property owned by an LLC. If you have rental properties or a business inside of an LLC and the LLC membership interest goes through the probate process, those assets are effectively frozen during probate. The reason being is that your family does not own those assets. The estate owns those assets, and your executor of your estate has limited authority on what they can do with the operations or the ownership of that LLC. And so if you have a rental portfolio or you have a business inside that LLC, they have limited authority on what they can do to continue the operations inside of that business, and therefore it could suffer over time during the probate process. And so what you can do instead is put the LLC membership interest inside of a revocable trust. When you pass away, it will avoid the probate process completely, get distributed out to your family, and then they can take over the control over that portfolio or the business much more quickly. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to some of our team.